Dr. Kath Hall explains the fact that about 11.6 million children live in households where they are in the upper poverty line. And also in the next paragraph deals with the food poverty line, which is also is indicated as being the families that are unable to afford enough food to supply them with a minimum daily per capita that is required for energy. So that tells us the inequalities that my Leonard colleague advocate Nkaitobi mentioned. It also tells us that the children that benefit from this National School Nutrition Program are not children whose parents can readily provide for them, and more so that during the COVID, when the lockdown happened, things became worse. Things became worse because, as you will see in this affidavit, some of the parents are people who were seeking work. Now they can seek work. Some of them were traders even at schools and cannot now come and sell their trades at schools. And that has dire consequences for these families. Then, my lady, that should then be that as you look at the fact that these are the socioeconomic circumstances that we're dealing with, where the majority of the children of the country live in poor households, and that 9 million of those children were benefiting from the school nutrition program, when steps are taken to try and deal with the consequences of the COVID-19 impact, a lot more needs to be done than to ameliorate the impact on those households and also to ameliorate the impact on the children. Now, we do acknowledge in the affidavit some of the measures that were put in place, such as the process for getting the top up to the child support grants, which initially we thought were going to be a top up of 500 per child, but was just 300 per child for 1 month. Later, then it reverted to the 500 being for the parent and the grant remaining the same for the child. We do acknowledge that those measures were taken. We do point out, however, that, for instance, with the child support grant, the top-up, if it had remained the 500 per child, it might have maybe ameliorated the food insecurity issues in the homes, and maybe assisted towards alleviating the hunger that we see. I mean, the applicants have already dealt with that and explained to us and showed us affidavits of parents and children who literally cannot eat. And that is a huge challenge. And, you know, as has been said by my learned colleagues for the applicants, also violates the rights of the children. So it's within that context that the role of the National School Nutrition Program must be understood. Before lockdown, all the years since it's been there, it's been to help the most vulnerable members of our communities who, when disaster struck in March and we had the lockdown, became even more vulnerable. And I think that's very important, because the steps that you then take to deal with the disaster and to deal with the socioeconomic impact of that disaster must take into account the pocket, well, not the pockets, if actually here, the majority of our population that is actually poor. And I think that is something that's crucial as by way of background for us to deal with in relation to then where does the school nutrition program fit in. The affidavit also deals with the fact that, very important, is that during lockdown, one of the sad things that's happened between March and now is that actually the food basket for poor households, or low-income households, has gone up. By the end of May, it had gone up by about 7%. The affidavit indicates of our expert, which shows that even if, for instance, you do have the top up to the CSG, you will still have a problem that food has become more expensive for everybody, but more so for the people who are in the low income. And I think we saw in the affidavit of the applicants that the family where they only have 500 rand for mealie meal and nothing else. And those are the lived realities of the children that are affected by the decisions that were taken by the respondents. My lady, just wanting to just go through the affidavit before I go to the legal submissions. One maybe important aspect to mention in the affidavit, Dr. Hall also deals with the issue of child hunger and malnutrition. And she explains how the Children's Institute have actually been monitoring the issue of child hunger, and there's actually over 2.1 million children who live in households where there wasn't enough food already before the lockdown. So we can imagine that has increased. And at paragraph 35 of our affidavit, she says that their families where over 60% of them cut the size of meals or skip meals or ate smaller portions and less variety of food because of financial constraints. And those are the people who live in the lowest income levels of our country. And lastly, the affidavit explains that in 2016, when the National School Nutrition Program was evaluated, it found that 4% of learners that were surveyed had not eaten at home the previous night, and 23% had not eaten in the morning. That emphasizes the importance of having this program at schools, because children get, and it's also set out in the affidavit, that children get 30 to 45% of their daily meal or nutrition from the food that they get from the school nutrition program at schools. My lady, I'll come back to the issue about whether the nutrition program advances Section 281C. I think my Leonard colleague, Advocate Mkaitobi, dealt with that, but I do have a few additions there to actually assist the court in unpacking what Section 281C means and what are the obligations of the respondents. My lady, I won't go into the details about stunting and the effects of child hunger, but they are there in the detailed in our affidavit. And I will then move to paragraph 47 of the affidavit, where our expert explains the relationship between nutrition and education. And I think my Leonard colleagues or the applicants also dealt with it. Very important that we remind ourselves that the program must be understood within the context that even government itself has said, which was that they want to have healthy and well-nourished school children who learn better. And if your program that gives them the nutrition helps them to concentrate and to develop and to also cognitively be able to function better in the school environment, then there is that link between the right to education and provision of nutrition. We're not submitting that it's solely responsible or should be providing for all the children's nutrition. I think there's one place where in the DG's answering affidavit, they mentioned that there's no obligation on them to provide noon. We interpreting the right as if they must provide breakfast, lunch, and supper for the children. I don't think that that's the submission of the applicants, nor is it the submissions of the amicus. But the point that we try to make there is that we have a program that has been adopted, recognizing a very serious need, which is the need to actually provide children with meals that will be nutritious enough to help them concentrate and advance in their schoolwork, and therefore advance their educational outputs. And we submit that the link cannot be denied between how children who have been fed and who have nutrition, and therefore the right to nutrition has been advanced, can then have better educational outcomes. Then, my lady, at paragraph 56 of the affidavit as well, our expert makes the point that when you consider how many children are reached by the National School Nutrition Program, it's very important that any proposal that was there to suspend or reduce that program and have negative consequences on the children needs to be assessed. Well, the impact of it needs to be assessed. You need to understand that if I'm suspending this program or I'm reducing it and only allowing these children, what is the impact on other children? And my lady, this is something that is very crucial. My Leonard colleague, Advocate Mugaitobi, mentioned the judgment from yesterday. One of the things I noticed in the judgment in the One South Africa movement is that at paragraph 136, where the court summarizes some of the arguments made by the Minister of Education, actually by the DG himself. He mentioned that one of the reasons they wanted the schools to reopen was that the ongoing closure of schools deprived millions of children of access to benefits of school nutrition program. I know they do submit that, they don't deny, but as my Leonard colleagues for the applicants have mentioned, the continued lack of provision actually means that they themselves are not doing what they say that is one of the reasons why the schools need to be reopened. We also submit, as explained in the affidavit, that if you're going to reduce or suspend a program like this, it should be for the shortest possible time, and you must place adequate mitigating measures, and you must put plans as to when you will resume. And I think this goes to what the applicants are saying in relation to plans not being properly made for resumption, for how we'll implement. And also, as they mentioned, what if we go back to the hard lockdowns we've had, how will they deal with it? And I think proper planning is very important. When you're dealing with the most vulnerable members of our community, you need to consider how your decisions really affect them now, in the short term, in the medium term, in the long term. My lady, one other last point I will maybe make in relation to the affidavit before I go to our legal submissions is that um, our expert makes the point, Dr. Hall, that if you have pre-existing programs and you do have a disaster, you must find a way to actually leverage on the pre-existing programs rather than trying new ones that might be struggling to work. And I think this, we see that when statements are made and submissions are made that, well, Department of Social Development was meant to come in and ameliorate and all that, those things fell short and they don't reach as many children as this National School Nutrition Program did, because you're now trying to devise a new plan. You must now think about how you'll register everybody, how will you reach them? Whereas you have a school nutrition program that reached 9 million children that you could have found different ways of implementing, and obviously following all the protective measures that are necessitated under the current situation in the country. So it is very important that that be kept in mind. So the affidavit concludes by also emphasizing the fact that rights are intersectoral, and actually the National School Nutrition Program as well, it was conceptualized as being intersectoral right from the start. So it cannot have, there cannot be this idea of divorcing the educational outcomes of it from the nutrition outputs of that. And maybe, my lady, now it's the time for me to move to our heads of argument, and I must maybe start with the argument that's linked with what I just said. So we make the submissions that when the this country reported to international treaty bodies in relation to how they are implementing and advancing children's rights. This is at paragraph 31 to about 36 of the heads now, not the affidavit. The answering affidavits of the DG had said that again, that they don't have an obligation to provide nutrition that stretches that way. And I know that our Leonard colleague has said that they're not really saying it in that way, but it's important, as my Leonard colleague, Advocate Nkaidobe, was saying, that we actually clarify what this right requires of them and what this aspect. But what we find is that on their own version, reporting to the UN Committee on the Rights of the Child and reporting to the Committee on Economic, Social and Cultural Rights under Article 11, they've characterized the very school nutrition program as a nutrition, as advancing the right to nutrition. And this you find at paragraph 36, where they say to the UN Committee that school feeding is offered via National School Nutrition Program, providing daily meals to almost 10 million children. Although provincial consultations process highlight the need for feeding to continue during school holidays, again, something to keep in mind, because we live in a very impoverished country, and steps must be taken to make this something that benefits children throughout. If they're eating during school, what do we think they're eating when schools are closed? And I do remember that in the affidavit of the minister, it was mentioned that it's only during school, it's only during. But you see, when the reports are made to the UN committee, it said that we're even thinking about maybe doing it when it's school holidays. And that is something that is not done as a favor to children. That is done as recognizing that we have a very impoverished country with people, parents who are not working, who need support. Children are hungry. They have rights in our constitution, and we've undertaken to implement that rights. But more importantly, my lady, the respondents cannot say one thing to the international treaty bodies and then come and try and say something else before domestic cause. They've said that this falls as part of one of the measures for school nutrition. Similarly, again, the paragraph below that still emphasizes that it provides, the program provides food to almost 10 million children. it's also addressing barriers to education. On their own version, they actually have linked the right to nutrition and the right to education, and that they're advancing them both through the school nutrition program. That cannot be denied, my lady. Equally, to the Committee on Economic, Social, and Cultural Rights under Article 11, the same thing was said. They were saying that the school nutrition program addresses challenges of malnutrition and stunting amongst children. And it requires a concerted effort between government, civil society, and development fund partners. Daily meals are provided to 9 million learners in 20,000 schools through the National School Nutrition Program. The program aims to foster better quality education by enhancing children's active learning capacity, alleviating short-term hunger, providing an incentive for children to attend school regularly and punctually, addressing certain micronutrient deficiencies as well, and that this school feeding is part of the integrated food security strategy for South Africa. It's not only an educational program that we're dealing with, it goes far beyond that. This, my lady, I make the point about this because at one point it was made out in the answering affidavit that it's just a byproduct. Nutrition and getting nutrition out of this is just a by the way. It's not really one of the main aims of our obligations. My lady, I link it again then to paragraph F, which is on let me say paragraph 41 and 42 of our submissions, where we actually then place the right to nutrition and explain what the obligations are under international law. I will not read through everything, but the point we make there is that Article 24 of the CRC provides for the right to health, and that health right includes nutrition. And then there's general comment 15 that on paragraph 44 that I have a quotation that says school feeding is desirable to ensure that all pupils have access to a full meal every day, which can also enhance attention to learning and increase school enrollment. The committee recommends that this be combined with nutrition and health education, including setting up school gardens, which South Africa has actually done. We actually have complied with this, and we're saying that we are, complying with what is required internationally. The problem is when then this COVID-19 came and we couldn't really adapt. And I think that is very important. And when you adapt, you must adapt in a way that enhances protection for children, not actually make things worse for them. And that is very important, Mali. One of the issues that was raised, and I think my Leonard colleague, Advocate Nkwadjobi, dealt with it a bit, is this issue of the obligations of the parent, primarily being on the parents versus the state. I think we set out the explanation that we draw from the Grootboom judgment and then the TAC judgment, and really the point being that there's where parents are in dire situations and cannot provide, the state has an obligation to step in. I just want to mention the fact that finds support as well in the CRC in Article 27 that makes it very clear that where parents cannot or are not able to actually provide for their children and there's a need, then the government must step in. And actually, Article 27.2 has a particular provision that says that even in relation to nutrition, then the state has to step in. And we know, we've said how which children we're dealing with here, children from the most poor population of our country, with parents who are unemployed, who've lost jobs, who cannot even go look for jobs, who cannot sell their wares alongside the road. Therefore, then that duty of the state to then help those parents becomes even more crucial, because otherwise, as has been said and it's been seen by the applicants, from the applicants supporting affidavits, is that children are literally not eating. My lady, then, if I can maybe talk quickly, just go to paragraph 66 of our submissions. I go there because there was an issue about regression and whether the steps that were taken are retrogressive, and I think it's very important to also remember that. So under the CRC, we have general comment number 19 that stresses that there should be no regression on socioeconomic rights. There's a quote that I have there, but the last part of the middle part of it actually says it. It says, in times of economic crisis, regressive measures may only be considered after assessing all other options and ensuring that children are the last to be affected, especially children in vulnerable situations. And I think that reminds again the state of its obligations. Granted, it was COVID-19 caught the whole country and the whole world off guard. But the point is that particularly there where disasters are and where the situations are difficult, the first people to lose out are children, because everybody else focuses on people who can do things for themselves and how they adapt. But we forget how we have to actually think about how will we protect children, how will we continue to give them what they're entitled to under the difficult circumstances. And also, as the general comment says, where you have to take some steps that might be regressive, you also have to look at how long are those measures going to be for? How can you actually make sure that the impact is not so severe? And also, when will you then take steps to remedy that? But you must still have steps that you've taken to actually unpack that. You cannot just decide without following the right process. Um, and my lady, this links with then with where we in the submissions we deal with the need for a child rights impact assessment, and link that with best interest. And they basically the argument is again that where state parties are going to take decisions, whether it's in crisis or not, and more so in crisis, they should conduct a child rights impact assessment in order to ascertain the effect of legislation, policy programs on all children in the nation, especially children in vulnerable situations, because that's where the children will probably be disproportionately affected by the violation or by the limitation of their rights. A child rights impact assessment should be part of each stage of a budget process and should complement other monitoring and evaluation efforts, which while state parties will apply different methodologies when doing this, they should use the convention as the protocol. So, my lady, in our view, there's no evidence that this was done before the program was stopped. Obviously, again, we take note that there was a crisis. But from what we see now and has been presented before the court is that no proper assessment was also done then to ameliorate and to plan. As my learned colleagues for the applicants have mentioned, there's been a bit of a scramble for now we have to reinstate. How do we quickly do this? Provinces must do their own thing. How do you? And I think that for us, my lady, indicates that there has to be a better way of doing it. And one of the other things that was said was the plan that DSD was meant to take over. But as I said, we've mentioned that as recent as the 25th of June, DSD reported to Parliament that they only reached, I think, 8 million households with food parcels, which is not nearly as reaching as many families for children, which is a problem, and they're still struggling to reach. Whereas we've demonstrated that with the school nutrition program, the reach was quite wide, and it was an established program that you could make plans to adapt it and make it more agile, taking into account the current situations. And sure, with maybe its shortcomings, we've seen on the papers that Western Cape managed to be agile and try to adapt for the benefit of the children. And I think that's what we must remember when you're taking decisions, that these decisions may not be easy. Obviously, they may put more strain on your resources or on your time, but you're dealing with the most vulnerable members in the country, and you have a constitutional duty to actually make sure that they remain protected. My lady, I just want to double check that I covered most of the stuff I needed to.
You're welcome.
My lady, there is a bit where we also delve into the interrelatedness of rights, and I think the international law supports that. But we've in the submissions we actually have set out from paragraph 15 of the submissions, set out the legal arguments in relation to how rights are interpreted in South Africa, the constitutional rights, and the fact that the respondents cannot come and propose a siloed kind of approach to the interpretation of children's rights. The child is the whole person. Just because we have section 28.1 C and 28.2 or 29A doesn't mean that you must read them in silos. These rights are interdependent and interrelated. And I think with the expert affidavit and as well as the legal arguments also under international law, it's very clear that that approach where you want to divide a child only has the right to eat at home when the school they only have the right to education is something that is not supported by the constitutional precedents that we have. Wait. My lady, I think I've covered everything, so I'll go quickly just to the remedy. Just to say that the amicus support the remedy that is proposed by the applicants. Say for we ask that if the court is with the applicants, when they make the declarators, the specific rights in the constitution are mentioned. So it would be good to see that section 28(1)(c) and section 21(1)(a) are clearly indicated. If the court is with the applicants. My lady, I think those are the amicus submissions. Thank you.
Thank you very much. Thank you. Mr. Oosthuizen?
My lady, there appears to be an impression that the minister and the provincial departments don't care for the children for which they are responsible. Since 1994, they have been running the NSNP. They have been feeding these 9 million children. And when COVID-19 came, they immediately started planning for the resumption of this feeding program because they were aware of their responsibility. The accusations that the minister is callous, that somehow there is a playing games with the court, is, with respect, unfounded. You have the chronology, you have the events, what happened, you know how long the department have been planning at the national level. It is precisely because of the concern of the department that a special meeting was called with the Department of Social Development to make sure that during the lockdown something is happening. Now, we live in a constitutional state where functions and responsibilities and duties are distributed also between different line departments. During the lockdown, this was the responsibility of the Department of Social Development. The Minister of Basic Education cannot answer for what happened during the school holiday because that was not part of her mandate. Yes, if you want to look at the state in general, you can criticize the state. But we are dealing here with a case not against the state, but against the Minister of Education. So this idea that somehow the minister doesn't care about hungry children is absolutely untrue. Now, we have advanced our case on a very specific basis. My learned friend took you to paragraph 9 in the founding affidavit. Now, can I take you there? You will remember that he took you to that paragraph and he said, this is our course of action. But my lady, please go back a few pages. Please go to page 00613 and look at the heading. This is part of the background to the application and paragraph 9 as well. It is quite easy with the benefit of hindsight to now elevate paragraph 9 as if that is now the course of action. In our heads of argument, we have listed all the paragraphs where attention is specifically drawn to the so-called refusal by the minister. And if I can go there, if I can take you through the relevant references quickly, can we first go to paragraph 006-14?
I'm there.
Okay. In paragraph 6, they refer to the announcement for the reopening of the schools, then the public undertaking that the NSNP would be rolled out to all learners, including those who are not physically attending school, and then the minister retracted this undertaking at the press conference, and they make quite an issue of that. Then the next reference or the next relevant reference is on page 006-22.
Sorry, what must I not take from paragraph 6? What's your argument?
No, I'm saying that what they emphasize in this paragraph is they refer to a so-called retraction of the minister.
Okay.
That is where the alleged refusal starts, and then this is developed through the founding affidavit. If you then go to page 006-22 and you go to paragraph 25.2, they in the middle they say there are so many learners at this school and so many learners at this school who will go without school meal as a result of the refusal by the respondents to implement the NSNP for all learners. So again, it is not the failure to supply meals, it is the refusal to supply meals. If you then go to page 006-24, paragraph 30, they explain why the application is brought on an urgent basis. Because there was a breaking of the undertaking to provide a daily meal. Not a failure, a breaking of the undertaking. Then, if we go to the next page, page 25, paragraph 33.
Sorry, I'm not following. Remake your argument on paragraph 30.
My lady, they say that the application is brought on an urgent basis.
Yeah.
Not because, remember, in paragraph 26, they've referred to an undertaking in respect of which there was a retraction. And now
Yes.
they refer to that breaking of the undertaking. So, but the allegation is not a failure. It is the refusal of the minister which makes this matter urgent. If we can then go to page 30, the next page, page 25, paragraph 33, they say funding is available. And then they say, last paragraph, at the time of the minister's retraction, at least 3 provinces had already been planning for the rollout of the NSNP to all grades. So again, it is not the failure on the 12th of June when this affidavit was deposed to that is the focus of the attack. The focus of the attack is the minister's retraction. Then on page 006-49. You find paragraph 95. Again, we have this incident on the 1st of June 2020, where they say at this briefing, the minister broke the undertaking regarding the NSP. So it is a constant refrain right throughout the affidavit. And it is not only passing references, each time the attention is brought back to that refusal and that retraction. Can I then take you to page 006-67?
I'm there.
It starts off with a refusal to ensure that all learners are fed as soon as schools reopen. Now, this is not a failure. This is a refusal. And it is not a
Does
failure.
it not boil down to the same thing?
No, my lady, because
Oh.
the evidence shows you that the department and the provinces have constantly been planning and making ready for this, but we're not saying it is without problems. And I will take you to some of the problems
When
that
did
they
they
are
start with this
experiencing.
planning? Sorry, Mr. Oosthuizen, when did they start with this planning?
My lady, they started with the planning already on 30 April 2020, but it was
When
part
they
of the...
handed it over to social development?
No, my lady, no. When the lockdown happened in March 2020, the schools were closed. Then the responsibility for feeding the hungry became the responsibility of the Department of Social Development.
Well, that's exactly what I've said, Mr. Oosthuizen.
Yeah, basic education then assisted in that period to the best of their ability. And remember, in this period, they don't provide the meals at schools because the schools are closed, the infrastructure is not available. It is the programs and the distribution centers of social development that is being used. But then the regulations got changed and they decided, okay, we're going to reopen the schools. On the 29th of April, the regulations got published. On the 30th of April, the minister said, okay, we plan to open the schools on the 1st of June. And that is when the planning in all earnest started to plan for the reopening of the schools and the resumption of all programs, including the feeding program. The minister and the provinces were planning for that from 30 April. Okay. Now, as they went on.
So they should have been ready by 8 June then,
Well,
because they now have 2 months to do that.
Well, my lady, they should have been ready, but they weren't.
Yes.
And we now have a situation where, if I can just take you then to the last paragraph, 006-75. This is now the concluding paragraph, and it refers to a refusal of the respondents to resume the NSNP for all qualifying learners. Now, my lady, we say simply that the thrust of this case and the cause of action was the alleged refusal by the minister. But there was no such refusal. In fact, we've been planning and preparing to the best of our ability to resume this as soon as was practically possible. Now, my lady, after COVID-19, it simply cannot be business as usual. Everybody must realize that. Now, if you look at the answering affidavit, it says to you, and I'm just going to give you the references, my lady. I'm not going to take you to each of this paper. In paragraph 7, that is on page 001-9, it is explained that we had a sudden emergency. Then it is explained at variance, and this is not, and this is where I part ways with the amici. This wasn't an economic crisis that built up or a health crisis that came. It was a sudden emergency. So it is very nice to quote international instruments that says that you must first do this assessment and then that assessment. But how do you do it in a sudden emergency? So that is the first point to remember. And that emergency isn't over. We are sitting in that situation as we speak. This is why we have a virtual court. Then the second point is that the NSP was developed and built around the availability of infrastructure at schools. Now, all of a sudden, we must make a plan. The meals must now be delivered to the learners who are back at school and also to learners who are not at school. But how do you do that? Well, you can get them to come and collect at school. But when, where, and how? And if they can't collect, if transport cost is too much, how do we get the food to them? So it wasn't simply a case of, okay, 8 June, schools reopen, and now it is business as usual. The inherent restraint in the program was that to roll it out, you use the infrastructure at schools. Now, if that infrastructure had to be supplemented, if we had to get extra delivery vehicles, if we had to get drivers, that doesn't happen overnight. That lack of infrastructure, my lady, you will find 011, page 14, paragraph 15. You will find it in paragraph 18, and you will find it in paragraph 26.3. We also point out that there was an economic implication. Even the private sector that normally supported us liberally had a problem because of the economic crisis that was made available. There were logistical problems even for the Department of Social Development during the lockdown. My learned friends have pointed out that they reported back to Parliament that they could only provide 8 million food parcels. Why? Not because they didn't want to, but because they had serious logistical problems. So this is not business as usual. And that is explained to you in paragraph 23. If you look at the planning that had to be done, we had to plan for COVID-19 measures. We had to plan for social distancing. And all of those things implicate the provision of meals. If you had to maintain a social distance of 1.5 to 2 meters between learners, how can you get them all to come to school at one time to come and get their meals? And if you are going to use staggered times, then who's going to be on duty to do the screening, to do the tests? So it wasn't business as usual, and there was a lot of logistical problems that had to be addressed. In paragraph 25, you are given an idea of the scope of the basic education sector. 24,000 schools. 24,000 schools. My learned friends now come and say that they quickly did a survey. Well, the survey that they did covered 0.2% of those schools. So we are not dealing here with a situation where the minister can simply overnight provide 9 million meals. It's simply not logistically possible. They also explain in paragraph 27 that they are in a constant state of flux. The one moment you've got one thing in place, then something happens, and then you have to revisit everything again. In paragraph 41.3, they explain that they are working with the provinces and some preparations will take longer. In paragraph 45.4, they explain the problems that they have with some suppliers. And then in paragraph 49, my lady, you have the feedback from the various provinces. They explain to you, we have scholar transport problems. We've opened up for certain grades and they are there at school. But other children, they must make use of scholar transport to come to school, get their meals and go back. And it's simply too expensive. They can't afford it. Then they also explain that at some of the places there's been crime, that some of the infrastructure has been...
Sorry, Mr. Oosthuizen, must I assume from this that it's impossible to get this program running?
No, my lady, I'm not saying that. I'm not saying that. What I'm saying is that the application, to a certain extent, is, with respect, naive. It expects of the minister to immediately make available the food, and the basis for that demand is that you cannot refuse. We've got an entitlement, you cannot refuse. And we say, but look at what we've been doing. We are trying our best under very difficult times. And that is why we say there was no refusal. We are busy with that. Now, my lady, can I go to the following? Yeah, okay. Those are our submissions. We say, of course, the minister care. Of course, the minister is responsible for this program overall. But she has intervened. She has called together the Council of Education Ministers. They have taken a decision. They have called together the HEDCOM, and they are busy addressing it. She hasn't forsaken her responsibility. And she is busy addressing this. Now, can I point out a few in order to deal with some of the submissions made by my learned friends? They say this case is not about refusal. We say the founding affidavit is clear. It is about refusal. They say, no, it isn't about refusal. And then the question arises, but in your own papers, it is clear that there's also a failure in the Western Cape. Some of the students in the Western Cape are not receiving meals. But you're not asking for relief against the Western Province government. Why not? Because it isn't about a failure. It is about a refusal. Then yes, my lady, I just want to, my learned friend took you, I've got a note here that I have to deal with this, but I just want to go to the page, 01175.
Zero double one.
011, page 70, 011-75. Yes. This also, yeah, this deals with paragraph 63, my lady. Now, my lady, it appears to me that my learned friends misunderstood the point that we were trying to make. The Department of Education has the mandate in government to deal with education. Now, when we look at the National Schools Nutrition Program, then we are talking about different levels of analysis. If I have one program, for instance, I build roads, that's my program. I build roads. This road will enable people to travel. It will promote their right to mobility. It will enable people to visit each other, the right to a family life. People will be able to visit. So it's one program that will pursue two fundamental rights. But I am not saying that children do not have an entitlement to basic food or nutrition. I'm saying that, of course, in terms of the National School Nutrition Program, if you qualify, you are entitled to it. But what I am saying is that the basis, the legal basis for that right, for that entitlement, flows from the program itself and from your rights under section 27 and 28. Let's take a practical example, the implication of my learned friends, the consequences or the implications that their argument will have. I have two children standing next to each other. The one is rich, the other one is poor. For the poor one, I say, you have a right in terms of section 29, and that right includes the right to food. But in the very next sentence, I say to the guy next to him, because you are rich, your right to food, your right to education doesn't include the right to food. So the contents of the section 29(1)(a) right now becomes relative. It becomes dependent on the particular circumstances of a case. I have never heard of any legal provision, not even a constitutional provision, being interpreted in that way so that in one situation it means one thing, and in another situation it means another thing. And to reiterate this point, the amicus makes the point that all rights, fundamental rights, are interdependent, interrelated, and mutually supportive. Precisely. You have a right to basic education, and that right is supported by, it is strengthened by your right to access to food and your right to nutrition as found in section 27 and 28. It is not part and parcel of the same right. Because, my lady, if we follow that approach, then if we go past section 11 of the Constitution, we can scrap everything. Because then we can simply say, I've got the right to dignity. And my right to dignity means the state must give me a proper job so that I can look after myself and live in dignified circumstances. My children must have a right to education. They must have a right to food. Because in the absence of all those things, dignity is an illusion. Now, surely you cannot interpret the Constitution like that. So my point is not a denial of an entitlement to meals for these 9.6 million children. And the minister is not denying that. What we are saying is, you can't bring that home under section 29(1)(a). Yes, you can bring it home under section 27. Yes, you can bring it home under section 28. And being part of the state, that is our constitutional obligation as well under section 7(2). There is such an entitlement. And if the Constitution didn't give you the entitlement, then the National Schools Nutrition Program gives you that entitlement the moment that you qualify. So we are not advancing the denial that my learned friends are suggesting. My lady, then we go to the relief. Now, if ever there is a demonstration of the flaws in this case, it is the relief itself. On 8 June, grade 7 and grade 12 returned to school. It was published in the Government Gazette, and you can take judicial notice of what is stated in a Government Gazette. What is also stated in that same Government Gazette is that on the 6th of July, that, my lady, is this coming Monday. On the 6th of July, grade 1, 2, 3, 6, 10, and 11 will be returning to school. That means that 8 of the 12 grades will be back at school on Monday. On my learned friend, Mr. Butlender's calculation of a thumbsuck average of 750,000 pupils per grade, that means that by this coming Monday, 6 million children will be back at school. And the terrible problem that we are facing at the moment will be reduced by 2/3. Then on the 3rd of August, 3 weeks later, grade 4, 5, 8, and 9, the rest of them will be returning to school. So from the 3rd of August, there will be provision of meals at school. And then this problem of having to deliver at houses or collection points will have disappeared. But now look at the relief that has been asked. Let's go to page 006-2. There you've got the notice of motion. Okay. If we go to paragraph 5 or prayer 5, my colleagues emphasized that this prayer is that the minister is ordered without delay to ensure that the NSNP is implemented. Now, without delay doesn't mean immediately. It means as soon as is practically possible. If we then go to prayer 9, The minister is ordered within 5 days. And 5 days here means 5 court days. The minister is ordered within 5 days to file at this court a plan and program which he will implement without delay. So the scheme of this interdict, the scheme of this relief is that you give a judgment, and let us say that you give the judgment this afternoon, or you reserve till tomorrow morning and you give it tomorrow morning. You give an order. Then what is contemplated here is that for the first 5 days, the minister must now prepare a plan and program which you must file with you under oath. That means that plan or program must be here in court by the 9th or the 10th of July. Then 6 million children are already back at school. So 2/3 of the problem has already been addressed. But on this order, she must now plan for all 9 million children. Then, if you go to the next paragraph, the minister must then file a report with this court under oath and provide copies every 15 days from the date of this order until the order is discharged. Now, that means that after she has made her plan and her program, then by the 30th of July or the 1st of August, she must report back to tell you what has happened. That is 2 days before the rest of the children return to school. Now, my lady, this shows you, with respect, if you look, and everybody said you must look at the totality of the case. Look at the totality of the case. I must tell you that I found myself on more than one occasion, reading these affidavits and realizing that I sit in chambers and I have no idea of the poverty-stricken desperation on the ground. My colleague, Mr. Butlander, took you to paragraph 75 of his heads of argument, which makes for tragic reading. We are not making light of the dire problems that are being faced by especially the vulnerable during these difficult times. But it is precisely because it is these difficult times that we are experiencing these problems. The department has been busy doing their best. If there is one solution that anybody could come up with, if the applicants or the amici could tell us, well, you could do this or you could do that. How do we deal with a supplier that says to us, well, I've got a contract, but prices have escalated by 7%. I want an increase in the contract price. If I have to get suppliers, I have to do so through a procurement system, because the rule of law and the constitution hasn't been suspended. If I know that the schools are going to reopen on the 8th of June, and I want to get a specific supplier, I have to go through a procurement process. Where, with any particular step that has to be taken, was there a failure or a negligence on the part of the minister or the departments? Yes, they haven't delivered. Yes, there are a lot of children on the ground that have not yet received the meals. We realize that. But that doesn't mean that we're sitting back and doing nothing. We've got a monitoring system in place. We've got the Education Collaboration Trust exercising an auditing function. And we are working day and night to address this problem as soon as is practically possible. And a structural interdict in this regard will, with all due respect, not help. Now, my learned friend has referred to the judgment that was delivered yesterday in the One South Africa movement. And he said to you that the only reason why a structural interdict was not granted was because the violation or the infringement of the constitutional right has not been demonstrated. Can I refer you to paragraph 184 of that judgment? As we have found, the applicants have failed to establish that the fourth respondent's decision, that is the decision to reopen the schools, was unlawful, irrational, unconstitutional, and invalid. As such, it follows that the consequent relief prayed for in prayer 4 falls away. However, and this is under the heading, my lady, supervisory relief. However, we proceed to deal with the issue in the event that we may be wrong in concluding that the applicants are not entitled to the declaratory and review relief in respect of the decision to reopen schools. So then they go on to say that even if there is a basis for a declaratory relief, this is not an appropriate case for a structural relief. And one of those considerations in the case, my lady, was the difficulty of dealing and administering matters when everything is a constant state of flux. Now, if we look at the facts holistically, was there a problem in that learners did not receive meals? Yes. What is the department doing about it? They are working and planning and addressing the situation as they go on. The national government making available the funds and providing direction, the provinces looking after the schools, and in the final analysis, the ground soldier for the implementation of the program is the school. And in that regard, my lady, it is so tempting. It's so tempting to follow a simple argument. You say, well, there are children on the ground that has not received meals. Therefore, the government have failed. But my lady, the word failure implies some or other dereliction of duty, some or other neglect. And if you look at what the department has done, nobody has said that they are not acting in good faith. Nobody has said that they are not doing their best under the circumstances. Nobody has come with a plan to say they could have done this better or that better. Under those circumstances, yes, as a fact, the children did not receive their meals. But to call that a failure, to attach blame to the minister for this, is with respect not correct. Under those circumstances, unless, my lady, if I can just check my notes quickly.
You're welcome.
Yeah, my lady, the amicus spend a lot of time on the position during the lockdown. That is, of course, not what this case is about. But I must, there's one thing that as an officer of the court, I must point out. And that is that I accept that the hardships during the lockdown continued, or it contributed to the crisis once the schools resumed. May I also, just for the record, my lady, inform you of something else? The amicus is not entitled to put evidence or information or affidavits before you, but you have the power to receive them in the exercise of your inherent jurisdiction. So far in these proceedings, you haven't made a ruling on that. So I would have no objection if you formally rule that it is part of the record. This should have been done before they even started their argument. I raised my hand in order to point that out, but I didn't want to interrupt my colleague. So if you would be so kind, my lady, to formally exercise that power of yours and receive that affidavit. Then the amicus also made the point that somehow the department says that it does not have the obligation to feed poverty-stricken children. That is not the correct presentation of our case. We accept that we have that obligation. Where we differ is what precisely is the legal basis for that. And we say that section 29(1)(a) is not the foundation for that right. That right is located or founded on other provisions of the Constitution or on the program itself. Then I've already made the point that when the lockdown happened, it isn't as if the department did nothing. We did start working with DSD and we had our contribution. My learned friend then made the submission that there has to be a better way of doing things. Well, hindsight is always 2020 vision. Under those circumstances, my lady, and although this is a very difficult case, I respectfully submit that the case that we came to court to answer was this accusation that the minister have refused, the minister have retracted, and that is the cause of the problem. It is for that reason that we haven't investigated or dealt with the failure at school level, why the program hasn't been fully rolled out. We demonstrated that there was no refusal by the minister. And this isn't the case of us saying, yes, we will do it one day. This isn't, that is a spin that is put on the evidence before the court by my learned friend. If you look at the answering affidavit, we are looking at this as a matter of urgency. We are following it up on a regular basis. So on that basis, we say that they cannot now, when it suits them, put the emphasis on failure, as if that is the be-all and end-all of their case. We realize that on the ground, there hasn't been delivery, but that has never been their real case. And on the papers, we show that we are, in fact, addressing those problems on the ground. Whether we do so to the satisfaction of the applicants, I don't know, but we are trying our best. Under those circumstances, my lady, I would ask for the case to be dismissed. Unless there's anything else that the court would like to hear me on, those are my submissions.
No, thank you very much. Nothing further. Thank you. Reply.
Thank you, my lady. I'll be brief, and with your ladyship's leave, my learned friend, Mr. Toby, will deal with one point after I have. I dealt with the others. Lady, yes. I propose to deal with 5 matters. Firstly, the repeated point about refusal. I just want to take your ladyship to what's actually in the paragraphs to which my learned friend referred. If your ladyship would go to the founding affidavit, that's page 006-14. That's paragraph 6 of the founding affidavit.
Yes, I'm there.
Lady, this is exactly, I don't understand my learned friend's problem. Let me just read your ladyship the second sentence. On 26 May 2020, the Director General of Basic Education made a public undertaking that the NSNP would, from 1 June 2020, be rolled out to all learners, including those who are not physically attending school. Now, we know 1 June became 8 June because that's when the schools. The minister retracted this undertaking at a press conference on the 1st of June. That's exactly what she did. On the 1st of June, she said, we won't do it on the 8th of June. We'll do it at some future time to be announced, to do it when at a date to be told. My learned friends, it's a spin. It's not a spin. She said, we'll do it when we've got context-specific plans. We'll do it gradually. We'll do it in stages. And she left it there. So she did, that's exactly what she said. Then secondly, if one goes then to page 22 of that volume, paragraph 25, it's 00622, paragraph 25.2.
I'm there.
Now, my learned friend left out a critical phrase from when he read this paragraph to your ladyship. Paragraph 25.2 says, in terms of section 38B and C of the Constitution, the applicants bring this application in the interest of the learner members of EE as well as all of the learners and parents of the millions of learners who have been negatively affected by the refusal of the respondents to roll out the NSNP to all learners. That's where he stopped, but he left out the rest of it from the first day of school. That's what she refused to do. She did actually refuse to do it. And when she refused to do it, she failed to do it. And that's why we asked for an order that it be done. So I don't understand that point. And then finally, on the question of refusal and failure, can I take your ladyship to volume 012, page 146. That's the famous smoking gun letter. 012, page 146.
I'm there.
This is now the letter to the heads of department. And the third paragraph is the one on which I wish to draw your ladyship's attention. The legal basis for the application is the right to nutrition and basic education. The applicants allege that these rights of learners are being infringed by the decision that the NSNP be phased in and not available immediately to all learners. That is the cause of complaint. Now he thinks it's something about a refusal, but it's about a decision not to supply. And if you go to the last sentence of the previous paragraph, the applicants requested the court to grant an order that the NSNP be rolled out to all learners, notwithstanding whether they are currently in school. So Mr. Mweli understood very well when he wrote his letter on the 19th of June what it was about. It was about a decision not to make it available to all learners. It's about not making it available to all learners. And it's about getting an order that it must be made available to all learners. But sometime between when he wrote that 19th of June letter and the 22nd of June, when he made his answering affidavit, he came to a new realization that it was about some sort of abstract refusal. It's not about an abstract refusal. It's about a failure to provide as a result of a refusal to do so. And I don't understand, with great respect, why a learned friend can't understand that the failure to provide as a result of a refusal to do so is the basis of this action, because of this application. That's what it is. Then secondly, our learned friend gave your ladyship a lot of, said a lot to your ladyship about it not being logistically possible to provide the 9 million meals and about the problems with suppliers. The problem is that that's not pleaded. That wasn't the case they came to your ladyship for. They said there's no right. They said it's very complicated. Of course it is complicated. But they never said the reason it's not done is because it can't be done. They repeatedly said, we're doing it. They said, we're doing it. Your ladyship will remember what was said in that affidavit, in the answering affidavit. If I can just find the passage, where they didn't, the case wasn't, we can't do it. The case was, we are doing it. And perhaps someone will help me find the passage in the. I'll be with your lady. I'll find it for your ladyship in a moment. If your ladyship will just bear with me.
Yes, I will.
There, it's quoted in. It's paragraph 11 of the answering affidavit. And that your ladyship will find at 011, page 12.
I'm there.
And so, what Mr. Mweli says, says, in a nutshell, as I'll endeavor to show, the case for the minister and the MECs is simply, without conceding or admitting any unlawful or unconstitutional conduct on their part, and without conceding that the legal assumptions and submissions by the applicants are correct, that ever since 18 March 2020, we in the basic education sector have used our best endeavors within the scope and ambit of the resources available to us to put reasonable measures in place for the continuance of the National Schools Nutrition Program. We are in fact doing precisely that which the applicants want us to do. And we have been doing so without judicial supervision under a structural interdict. What they have not been doing, what the applicants want to do. They have not been providing meals. They have not been providing meals to 3/4 of those who qualify. And so that was the defense. The defense is we're doing what we've been asked to do. The short answer is you're not doing what you're asked to do, and that's why this litigation was initiated. One of the striking things about this case is the shifting goalposts of the respondents. Your ladyship knows that we were first told, and the public was told, and the learners were told, that the meals would be resumed when the schools reopened, 8th of June. All meals would be resumed when the schools were opened, 8th of June. Then in the answering affidavits, your ladyship was told all meals will be resumed by the 22nd of June. That didn't happen, but that magic date of 22nd of June had to be met. So the first step was your ladyship, the public were told all meals by the 8th of June. Then they were told all meals by the 22nd of June. Now my learned friend says you'll get all meals by the 6th of July for some and the 3rd of August when the schools reopen. In other words, the reopening of the schools is now, not of the schools, the return of the classes, he now suggests, is the date when it's going to be done. He says by the 6th of July next week, certain grades will return to school and they will then get the food. And he says on the 3rd of August, others will go back to school. And after that, into his words, the problem will then fall away because the food will be provided then. Now that's another version. Now the reason why we ask your ladyship to order a structural interdict is that this continual backsliding is what causes the need for some supervision and some reporting. We don't know what will happen on the 3rd of July and on the 6th of August. I beg your pardon, the 6th of July and the 3rd of August. A, will the classes actually return on those days, or will there be another postponement? Secondly, if the classes do return, will they actually be fed on that day, or will there be another postponement? There's been a continual backsliding, and the reason for structural supervision is that the court needs to be satisfied that the meals are being provided. And it's not a question of good faith or bad faith. It's a question of whether it's happening. And if it's not happening, and it's plainly not happening, and if there's a continual backsliding, then there needs to be judicial supervision. So that's the second point. The third point is the question of the right to food, where my learned friend talks about somebody who has a rich child and a poor child. I'm not sure how that happens, but okay. The point is the state's obligations, the state's positive obligations generally are qualified by what people are able to do for themselves. We don't have a nanny state. We don't have a state which has to provide everything to everybody. Generally, what happens in most instances, the people who have the rights, if they can fulfill the rights by their own efforts, then they must do so, and the state doesn't have an obligation. There's a right of everyone to access to housing. I can't go to the state and say, give me a house. I've got a right to housing. They'll say you can afford to pay for it yourself. And so many of the rights, and particularly the socioeconomic rights, are related to the two things. Firstly, to the ability of people to provide for themselves. Secondly, and most fundamentally, to the obligation of the state to take most care in relation to those who are most vulnerable. And that's the principle which is stated in the Grootboom case, where we've quoted it in our heads of argument, where the Constitutional Court said, what's a reasonable measure? One of the tests for a reasonable measure is whether it gives priority to those who are most in need. That's how our rights structure works. That is the rights structure of our Constitution. And so to say a right is relative, yes, all rights are relative. Well, not all rights, but many rights are relative. And certainly the right to demand a benefit from the state is very often dependent upon whether you can satisfy that need yourself. And if you can, then the state is freed of the obligation. Then the fourth point is there's nothing, and the program recognizes that, because the program says it's only for those in the lowest 3 quintiles. We're not going to provide meals to those whose parents or caregivers can provide for themselves. No one has ever taken any objection to that, to say that you could never go to court and say that's a breach of the rights of those in the first 2 quintiles. The short answer would be no, the state's obligation doesn't extend to those who can provide food for themselves. and the NSNP recognizes that. Finally, milady, the question then arises again of a structural interdict. And here my learned friend, I'm afraid, doesn't, I think, understand what it is that the applicants seek. The applicants say two things. They say the state should be ordered to provide them the meals to which the children are entitled. And secondly, it says that this applicants ask that the implementation of that order, the compliance with that order, should be monitored until such time as they have done so. If on the 3rd of August, all children in schools, all children who qualify are receiving meals under the NSNP, whether at schools or otherwise, the minister and the MECs will file a short report saying, we're happy to report that now it's being done everywhere. Here's the evidence that it's being done everywhere, and the order will be discharged. So the proposition by our learned friend that it will be discharged, the order, his proposition really is this: the food will be provided, and therefore there's no need for a report, or there's no need for a structural interdict. The answer is, when the food is being provided, there's no need for any further reporting, because then the state will have complied with its obligations. We'll all be very happy, and we can get on with our lives, and the children will no longer go hungry. But that is why, the reason why judicial supervision is necessary is the constant backsliding from the 1st of June to the 8th of June, from the 8th of June to the 22nd of June, now from the 22nd of June apparently to the 6th of July and the 3rd of August. Who knows what's going to happen next? A form of reporting will make the respondents understand what they have to do. They'll have to report, and if they comply, all good and well, everyone will be happy. If they don't comply, we will be back at court. We'll ask for an order for them to be further told what they should do. But I come finally, milady, to the where I started really with my opening remarks. This is an unusual instance of a claim for the enforcement of a right such as this, because in this instance, the state hasn't said we can't afford it, and neither has it said we can't do it. To the contrary, it says we have got the money, and to the contrary, it says we're going to do it. The problem is the repeated backsliding on dates as to when it will do it, and in particular, all of it triggered by the minister's announcement on the 1st of June that it would know the food, contrary to what had previously been promised, the food will not be provided to all learners who return to school, which of course is return to their classes, which of course exactly what has happened. Milady, if I may ask my colleague to deal with the question of the interplay between the rights, I have no further submissions.
Thank you very much, Mr. Makatubo.
Thank you, my lady. My lady, there is one issue I will deal with. I've also been asked by the amicus to bring to your ladyship's attention a judgment which they say provides a foundation for introduction of evidence under Rule 16, capital A. It is Children's Institute versus a presiding officer. It's 2013, volume 2, SA 620. It's a constitutional court decision.
Thank you very much.
Thank you, Melody. And then if I may deal briefly then with the one question which I believe is at the heart of the legal submissions by my learned friend, which is what is the legal foundation of the entitlement to nutrition? It seems that my learned friend concedes, despite having denied it in the answering affidavit, that the right to basic nutrition under Section 28 provides a legal foundation. And the right under Section 27, the right to food, also provides a foundation. The question that then remains a point of dispute is whether or not the right to a basic education provided for in Section 29(1)(a) also provides a legal foundation for the right to receive nutrition. We submit that it does. My learned friend makes two arguments against the interpretation we propose. The first argument is that textually there is another right. Secondly, he says in any event, you have this confusion between rich and poor children. Mr. Badlander has responded to the second argument, which is the distinction between rich and poor children. But it is also an absurd argument for another reason. Take, for instance, a child who doesn't have a textbook. The state can hardly argue that I cannot draw a distinction between a child who has a textbook and a child who has no textbook. And precisely the same situation happened in the judgment before Justice Colapan. Those children in Limpopo did not have textbooks, but there were also other children in Limpopo who did have textbooks. So the mere existence of children that were already enjoying the right could not be used to deprive those who were not enjoying the right, their entitlement to the right. Take another example, children who do not have desks. And this was a real case in Madzodzo, a decision we have referred to in our judgment, in our heads of argument. It was a judgment by Justice Hussein in the Eastern Cape. Many other schools did have desks, but the specific schools that were before court did not have desks. Take another case, again in the Eastern Cape, Center for Child Law, children who do not have classrooms. Other children did have classrooms, but those who did not have classrooms were in court demanding the entitlement. So the mere existence of a comparator that is in a better position is not a legal justification to deny the claimant who is before court if they can illustrate that they are not enjoying the benefit. In fact, that existence of a comparator is a powerful illustration that the person who is denied should be put in the same position as the comparator. So the second argument itself can simply be rejected. The question as to the text depends on how one construes section 29(1)(a). We have pointed out three powerful reasons in our heads of argument why nutrition should be seen as part and parcel of the right to a basic education. The first is a historical one. We have shown that in our scheme of the Constitution, history matters. Children who come from poor families are unable to access education for a variety of disabilities. One of them is poor nutrition. Nutrition helps them to achieve their entitlement to education. Without food, education is itself unattainable. That does not mean nutrition plays a supplementary role. It means nutrition plays a central role in the realization of education. The second point we have made is that when you examine the state's programs themselves, we have shown on BIFA and we have shown on Section 27, both of those cases, a judgment by Justice Colapan and a judgment by Justice Nafsa, who say in order to ascertain the scope of the right, you have to look at the program that the government has put in place and particularly its plans. In those cases, they showed that even though the state denied that textbooks were part and parcel of the education, their internal policies showed that they recognized it as part and parcel of the right of education. In this case, the internal programs of the government show that it recognizes nutrition as central to the achievement of the right of a basic education, independently of whether or not it plays a supplementary role in reducing hunger, malnutrition, poverty, and starvation. It is also crucial. It serves a distinct utilitarian goal insofar as education is concerned. So we have shown by reference to the internal programs of the government. And we've shown by reference to the RDP document, by reference to the 5-year strategic plan document, and by reference to the 2016 annual report of the government, that the government has internalized the right of education as necessarily including the right to nutrition. So it's part of education for that second reason. But then thirdly, we have asked your ladyship to construe the right in the light of the Bill of Rights. And we have illustrated the point that nothing is more undignified than starvation, particularly the starvation of a child. My learned friend says that a misuse of dignity ultimately reduces dignity to nothing. We, in this case, suggest that this is precisely the sort of case where dignity plays a very important residual role in informing the content of the right to education. The words in section 39(1) of the Constitution that say that whenever you engage a right in the Bill of Rights, you have to interpret it in the light of dignity, equality, and freedom. If those words have any case where they are directly applicable, it is a case such as this. Otherwise, to interpret the right of a basic education, absent the entitlement to being fed where your parents cannot afford to, ultimately reduces the right under section 29(1)(a) into an empty shell. And then, of course, finally, as the amicus points out, these rights are interdependent and indivisible. This point about the interdependence and indivisibility is not a point we have plucked from international law. It is recognized by the government itself. If I can take your ladyship to 05840 of our heads of argument, particularly paragraph 92, you will see the point made there about the interdependency and the indivisibility at paragraph 92, 052/40. This is the 2016 report by the Department of Basic Education, and it talks specifically about the logic of the school nutrition program. And then it says school nutrition programs, school feeding schemes, food for education programs, and take-home rations are all responses to poverty. In other words, they fulfill section 28, which is about nutrition and the poor nutritional status of children. There are two main groups of arguments in support of feeding children in schools. The first group is a nutritional one, and the second is an educational one. However, it is difficult to separate the two, since well-nourished children are assumed to perform better at school. It is impossible to think of a way in which you can segment, divide, and ultimately deprive of content section 29 rights. So we would submit with respect that the final argument in support of reading section 29(1)(a) to include nutrition is the admission by the state program itself that it is impossible to separate the two. In fact, the two should be read together. It is not as if the right should be taken away from section 29(1)(a) in order to be realizable. It should remain as part and parcel of section 29(1)(a). That, of course, does not mean there is no general right under section 28(1)(c). And one, of course, understands why the Department of Education wishes its argument in this regard to be upheld. It ultimately says this is a generic state responsibility and not a specific Department of Education responsibility. And yet, by holding that it is part and parcel of section 29(1)(a), your leadership sends a very powerful message, because your leadership sends a message not to an abstract government, an abstract state that we cannot see. Your leadership sends a powerful message to Mr. Mweli, who is the Director General of Education, and your leadership sends a clear message to Minister Motsecha, who is the Minister of Education. In other words, we have a right that is concrete and realizable, and we have a respondent that can be held to that right. That then leaves one issue, which is the question of the remedy. Mr. Bartlander has already addressed your lordship around the question of the necessity for the structural order in the light of the responses we had from our learned friends. I had done that in the opening address. I will not expand on that. But I want to emphasize one point, which is that the declaratory order is also especially significant. Declaratory orders are not mere pieces of advice. Declaratory orders serve a powerful constitutional function, because what they do, they clarify the rights in the Constitution. They clarify the obligations that are borne by state functionaries, and they translate abstract constitutional notions, abstract constitutional values into tangible, realizable goals. So it is crucial to give the declaratory orders that there are rights that exist and those rights have been violated. In that way, what your leadership does is that your leadership gives a voice to those learners, 9 million of them, who today are still hungry because the government keeps shifting the goalposts. Thank you, my lady.
Thank you very much. Does the amicus want to say something, Ms. Ozal?
Thank you very much, my lady. We find, but for the point that my learned colleague advocate Mukaitobi just pointed out, that there is actually a judgment by the Concord that deals with the fact that if it's in the interest of justice, an amicus can, in terms of Rule 16A, be allowed to file evidence. And the Children's Institute, who are the amicus here, were the people who took that matter to the Constitutional Court. So that is the only important aspect from our side. That we
Yes, and there doesn't seem to be an objection to the affidavit anyhow. So,
yes, my lady.
yes, thank you very much.
Thank you, my lady.
Thank you very much then. Thank you for once again for the host for hosting this and for the recording. Thank you to all the parties for the heads and the argument. Obviously the matter is brought as an urgent matter. The content thereof is in its very nature also urgent, and I will postpone the judgment sine die, but I will bring out the judgment as soon as is humanly possible. My registrar will email the relevant parties with the judgment, and we will also upload it onto case lines.
As
Once again, thank you very much.
As it pleases the court, my lady.
As it pleases the
Thank you.
court.
We will then leave the meeting. Thank you very much.
Thank you, my lady. Jeff, you still there?
Yeah, hi, Marius.
2 steam trains on different tracks running past each other in the middle of the night.